What's up, everybody? It's Stephen A. Williams, president and founder of the creditpressshop.com. And in this video, we're going to talk about fighting back against third-party debt collectors who buy credit card debt. And specifically, we're going to talk about what you need to do. And I'm just on a phone call with the gentleman where he had stated that he had lost in court and that they were actually forcing him into arbitration. And I did not see the original court summons. It's been more than a year ago, and I didn't see what the response was. But speaking with him, what I can what I can guess, my best guess would be that an affirmative defense was not put in action to where the judge would have a good reason to uh, request that the plaintiff attorney produce certain documents, and then those documents that would be requested would not be able to be uh, produced by the plaintiff attorney because they won't have access to them. So let's set the stage. We all know that when you go to court, you look on that list that's outside the courtroom. There's a list of defendants, and it'll usually have one or two different plaintiff attorneys that are on there when it's these debt collector cases. So you already know that the uh, the judge and the plaintiff attorney are very familiar with each other because the only thing that's in common with them with the whole thing is that those two are going to be involved and different people are going to be coming up in various cases, but it's going to be those two involved. So with that understanding, you got to get that judge into the mindset of, hey, uh, I'm not trying to run from this debt. What I'm trying to do is I'm trying to get all of the information so I can make an educated decision on how I'm going to move forward with this case. And that is the way that they really want you to move forward in these. They don't want you denying everything. I'm seeing a lot of people that are when they submit to us to just review what they had submitted to the court and wondering why they lost or why they're not getting anywhere. And it's because when I look at them at their documents, it's just stating deny, 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 deny. And you see that a lot on YouTube where they're telling people just deny everything. You never had a contract with the debt collection company, regardless, just deny it and never pay it, and nothing's going to happen. And then we see people that are losing these cases and they're getting sued, they're going to court, denying everything, and then all of a sudden they have a judgment and then they're getting their wages garnished or their bank account frozen. And so the information that you're getting from these other channels, they don't have the experience that we have with doing this stuff. And so what they're putting out as information is not going to work for you. So I'm going to give it to you flat out, the one specific thing that you can work on. One specific thing that you can work on to get you to either extend your case or to potentially get it flat out dismissed. Now, there's other things that you can add, but I don't want to overwhelm you. I just want to talk about the one specific thing. And this would also work if you're going to try to get your case open back up on appeal. When it comes to credit card debt, in the you get a court summons, third party is going to say that they purchased the debt. They're going to produce all of the affidavits and the bill of sale. They're going to produce all of these documents. They're even going to produce one or two of your statements, your final statements, which again, thanks to representative here in Wisconsin, that was the actual person who made this whole domino effect where one or two statements from your credit card balance, from your credit card debt was good enough to actually win a court case, unless you do what I'm about to tell you to do. So now, if you read your court summons document slowly and you analyze what they're actually saying, you will see that there's a point in there where they will actually say that this is the claimed amount. So let's just say the claimed amount is $5,000. And then they're going to have a couple of statements, and then they're going to have an affidavit. Like they're building everything to present it to the judge, to say this is, we got everything. This proves it. Just open and shut it down. Get my judgment so I can start garnishing or freezing and taking money out of their bank account. But if you think about it, with the words that they use to prove the claim, this is the claimed amount, $5,000. How do you prove that I owe you $5,000? And if we just go just basic off of that right there, you could tear their whole case apart, because you could say that the two statements that you gave shows a balance of that, but it does not show how you got to that balance. So to not offend the court, to not offend you, I'm just asking you to give me all of the charges from day one, all of the charges to prove this claimed amount. I want you to give me the charges. I want you to give me the payments that I've made. I want you to give me the disputed charges that I had, because everyone has disputed charges on their credit card. I don't care. Everybody does. I want you the dispute. I want the payments. I want the charges with my digital signature or my PIN codes. I want all of the payments that I've made. I want all of the credits that were made, any rewards that were credited back. I want all of the disputed information given to me. I want all of the interest rates that were charged so I can review that. And then I will review all of that information, and I will see if that information proves the claimed amount that you're showing right here. Um, Something that you'll usually see, which is crazy, is that the amount that they had, if they're able to even produce those documents, I've never seen them be able to produce the original creditor. They are able to produce it, but the third-party debt collector, they are not going to be able to produce it, because when they sell that debt to that debt collector, it specifically states on the affidavit that they take responsibility for everything, and everything that we gave you on that digital file is all you're going to get. You're not going to get any of that other information. And they're really, by law, they're not even able to give them all of that information, because that's internal information that's maintained by the credit card company. Now, if you're being sued by the original creditor, they're going to send you a big stack of everything and say, hey, here's everything that you just asked for. But the original creditor, but the third party debt collector won't be able to get that information. So then that backs them up into a corner to where they have to make a decision. Because if you go into court, the judge is going to say, where is that information that they requested? Because they do have a right to review all of those documents. And that makes the judge look okay with their friend, the debt collection lawyer that they see all the time. It's just a reasonable request. And usually what will happen is that third party debt collector will ask for more time. And then when they have the new court date come up, if you do show up, they'll usually say, we would like to dismiss this case because we were not able to get those documents, or we want another 30 days or 60 days to get those documents. And then you should say that I want it to be dismissed because they've had enough time to get that information. And the judge, 50-50 chance that they might dismiss it. Or they might just dismiss it right off the bat, because they may say that we're not going to be able to get that information and we want to dismiss this case. They could do it right off the bat when you make that request in your summons response. So let's back up a little bit, because I don't want anyone to get confused. When you get sued, there is a court summons that you must respond to. If you respond to that court summons asking simply for what I just told you in this video to do, and then they don't, and then your court date comes up and they don't have that information, they may say that they want to dismiss it. You can ask to have it dismissed, or they may ask to have it more time, and you can say, I want to have it dismissed because we've given them enough time, because I responded to the summons in the time frame that the court requested me to do it, and they did not produce those documents when we came to this hearing. If you've lost your case in the past and you still have enough time to do an appeal, because every jurisdiction gives you a certain amount of time. In my state of Wisconsin, they give you 6 months, but you have to request that appeal. You have to give them some information that you believe would give you a chance of winning. You can't just say, I want to appeal it just to open it back up. So utilizing the information I just gave you in this video, you would be able to have that come back up on appeal, utilizing the information I just gave you in this video. If you haven't done it, most people that I've seen and reviewed their court summons responses, they haven't done it. You can utilize that, and you can either force them into dismissing it, or they will ask for more time and then they would, you know, dismiss it later. We've seen them try to hold people up for a whole full year because they're just hoping that you won't show up to court, that you'll just forget about it. And then, or if, you know, it could be a situation where they might come to you and say, we would like to settle this account, and they could give a very good settlement offer. And that's, you know, that is a personal opinion that you could do to be able to make, to be able to move forward. All right, so I'm gonna end the video here. Please like this video. Please subscribe to the channel if you haven't done that yet. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process, my two-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to check those out, to get your TransUnion, Equifax, and Experian reports. If you have debt collectors coming after you before a summons, you can grab my 3-pack of letters. Please make a donation if you do that. Statute of limitations, debt validation, and cease and desist collection activities letter. If you have court summons where third-party debt collectors coming after you, I have a link below. The links are for below or for all of our different services, but there's a specific link below where you can get help with third-party debt collector court summons. Thank you for your time. This is Stephen A. Williams, President and founder of thecreditrepairshop.com.